Let's elaborate on that case that you just referred to. This is the case of the criminal, if I'm not mistaken, who claims some sort of Aboriginal ancestry, but is not an Australian citizen, and therefore, according to the High Court, can't be deported. Is that correct?
Yeah. So Kiwis can come over from New Zealand, and they have a right to live and work. But if they are convicted of a criminal offense, we often deport them back to New Zealand. And this gentleman, after release from prison, claimed Aboriginal status. And, 4-3, our High Court says, well, there's this new category of person that the federal government can't deport based on these well-known constitutional concepts such as otherness. I mean, it was just a panoply of woke verbiage, and 3 out of the 4 of the majority judges were appointed by the coalition, by George Brandis. It just shows you how bad our coalition governments are. They get in and they appoint, non-conservatives to everything. The ABC, the Human Rights Commission, the High Court. I mean, really, you wonder what the point is sometimes of voting for these people. But
the people who wrote the Constitution, they didn't envisage the sort of culture we're living in now. Isn't there an argument for the fact that the High Court is simply applying to constitutional law the cultural mores of today?
Well, it's not their job. Keeping pace with changing mores is the job of the elected parliament. If you prefer to be governed by judges in some sort of juristocracy, I don't think that would be a very attractive setup, but go ahead and move somewhere that does that. There's no legitimate authority for them to do that. So I just think it was a shocking decision. Now, obviously, in a federal system, somebody has to play umpire and decide between the states and the center. That was supposed to be their main job, but they always side with the center. I exaggerate slightly. We have the most dysfunctional federal system in the democratic world because our top judges have ruined a nicely balanced federal setup by always siding with the center. Again,
I like the analogy that you make at one point in the book that you often play pickup basketball where there's no referee or umpire and all the players impose the rules themselves voluntarily. Why can't that apply in constitutional matters?
Well, we know that when stakes get high, you have to have a referee and umpire, but you assume that the referee walks onto the court thinking he or she's going to apply the rules, not that, hey, I can make up a new game because I don't think the game you're playing is socially just because, you've separated the men and the women and I'm some kind of woke referee. I want the men to be playing, put a skirt on and go and play with the women. That's not the job of an unelected judge. So, but anyway, thanks for the plug on my book. Appreciate that.
That's all right. Well, I don't want to move off it just yet because I just want to talk about freedom of speech because it's a particularly important topic to all of us. I mean, you repeatedly refer to the implied freedom of political speech in the Australian Constitution, which was found by the High Court under a very intense magnifying glass in the mid-1990s. Now, free speech today is diminishing in Australia. I think it's pretty conclusive to argue that. Why can't we have that written in some sort of Bill of Rights, James?
Well, again, you buy the attitudes of the governing juristocracy with the Bill of Rights. So if you actually go and look at the implied freedoms are not a personal right. They're a limit on what Parliament can do related broadly to elections, although they've extended it to prisoner voting, things like that. But here's the thing. If you go and look at, since the 1992 case, ACTV, there have only been, I think, 5 times that the High Court has struck down legislation. Every single one of those post-1992 times, which party's legislation do you think the judge has struck down? I'll give you a clue. It sounds a lot like liberal.